does.
All right. Good morning. Good morning, everyone. So there's a slight amendment of the title of my keynote, as you can see from the screen. I thought there was also a need to look at the emerging AI regulation landscape in Africa, because just a few weeks ago, it became obvious that some countries on the continent are also looking towards legal framework. They are moving beyond strategies, so developing legal framework. So I thought I should add that, and that's why we have that slight amendment. I think it is also important that before we get along on this discussion, to lay some basics, because I want to believe not all persons are initiated in the in IP research. I mean, not everybody is in that field, so it would be nice to get so that for easy flow, we understand what we mean when we talk about intellectual property. And I'll use the common acronym for it, IP. Intellectual IP simply refers to creations of the mind, and also creations of entrepreneurship. And if we look at it from that angle, it means that IP is broad enough to cover things like copyright. So think of the software powering the laptops you are holding. There's copyright in that. It also includes things like patent. The software powering the laptops you're holding in some countries can also qualify as inventions for the purpose of obtaining patents. There is trademark, which is marked services that are used by businesses, that are used to identify goods and services. There is industrial design, which is if you like, the technical drawing, the technical designs, that upon which products, even the laptops you are holding, are manufactured. There are a lot of them, but just those are the main examples. And for us as Africans, our traditional knowledge related to our biodiversity, our genetic resources, I also regard them as IP. For instance, the use of Udia by the San and Khoi indigenous peoples, it could also be related to our cuisines, our way of dressing, obviously, and then we'll be looking at traditional cultural expressions, which are the expressions of traditional knowledge. All right, so these are some of the examples I think I should just lay down before we get along. So for my discussion today, I will be looking at what do I mean by techno-legal analysis, okay? Also, what is the connection between AI and IP? One of the speakers yesterday, Professor Okore in a keynote, and Mr. Monkari, Dr. Monkari, I've made some submissions that I believe probably be useful for our understanding of the connection, but I will go a little bit deeper, in my keynote today. Then, of course, we will look at the emerging AI strategies and what IP has got to do with them. Essentially, we'll be looking at the language used in those strategies that stick to IP, okay? And then we will look at, once again, the emerging AI regulation. And then I will end with some final thoughts and query, and I hope that my not so beautiful slides will be found engaging, and I'm also hoping that they will contain enough power to hold you, through the few minutes that we have. Now, techno-legal analysis is emerging obviously because of the advancement of digital technology. Okay, and it simply tries to look at, tries to combine both legal and technical expertise to examine the impact of law on technology, maybe digital technology, if you like, and also the impact of digital technology on law. And it finds relevance in several areas of law that interact with digital technology, like IP, like cybersecurity, data protection, e-commerce, e-health, areas of law that interact with digital technology. Techno-legal analysis finds relevance, and if you look at the literature, you'll see that scholars are beginning to engage with them from that angle. So what that means in simple terms is that for a legal scholar to be able to address the technical issues or technological issues in their area, you need a little bit of knowledge or expertise on how the technology works and how it impacts that area of law. Okay. Unfortunately, I am not a data scientist, I'm not a computer scientist, I'm a lawyer from undergrad to PhD. But I'll try to simply to look at the connections from my limited knowledge so that to ground my our discussion today. So, and what my engagement in this through the techno-legal analysis is trying to resolve is to actually find out whether there is need for, in view of the emerging AI technology, whether existing IP laws as they are can actually apply to AI without any form of changes to the law? Or do we actually need to revise the laws, amend the laws, to catch up with the new AI reality? Or do we need to develop new IP rules to catch up with the current AI reality? And that is what a techno-legal analysis engagement with AI and IP should be, asking, as scholars in the field. Yeah. These questions, at the end of my presentation today, I'm not sure if I will be able to answer these questions, but what I intend to achieve is to whet your appetite and ignite your thinking towards those issues, because as you engage in research for the IP scholars in the room, or those who will be interested in exploring the connection between AI and IP, how you should begin to think of, such research, such connection. That is essentially what I hope to achieve with my presentation today. Now, for the experts in the room who understands how the AI ecosystem works, from training of AI systems to content generation, you will know that you will see, or you will agree with me, that data is always at the heart of the system. One of the speakers in the last plenary yesterday said the problem is not necessarily the way AI systems are used, but the problem is in the data that they are used, that are fed into their training. So you see, from the very beginning, data is needed to develop the foundational models. Okay, and the foundational models operate as data to feed into the generative AI applications that we as users eventually engage with to produce content. Okay, and as IP scholars, when we hear data, we begin to think of IP. It could be copyright, it could be patent, it could be trademark. It could also be traditional knowledge. It could obviously be in the industrial design. But if you look at the literature, you look at the cases that we will try to engage with, and policy statements that have been made by some countries, the focus have been largely on copyright and patent. So pardon me if I refer more to those two in the course of my discussion today. So you see, the point I was going to make, I said as an IP scholar, when we when we hear data, we're already thinking of IP. So from the initial planning and development part of AI systems, you see that there is data, so there is IP. Of course, at the end, the content generated, there is also IP. At the middle, the foundational models, the generative AI systems themselves. Because if you take your minds back to the definition of generative AI or AI generally, you would agree with me that they are powerful software, powerful computer programs. Okay, somebody said that is a way of simplifying the AI system, but I don't think there is any better way to describe them. They are powerful algorithms, powerful software, powerful programs that, you know, try to mimic human thinking, human actions, but of course not all human actions. You know, so then of course the data sources, like I said before, as IP scholars, when we hear data, we're already thinking of IP. So which to me means that from an IP context, the data sources that are upon which IP stack forms from which the foundational models are created, you know, for the training of AI systems, can be from three sources: ineligible IP and public domain materials. That is, think of your pictures, think of books, think of articles that are no longer within IP protection, for which IP protection has exhausted, because IP protection is not perpetual, it is limited. Okay, depending on the IP in question. This is not an IP class, so I won't go into those details. So please just flow with me. It could also be IP materials that are subject to limitations and exceptions, or that have been produced based on open access licenses. Okay, then of course, you will find that the data can be IP materials that include, IP materials obviously including TK and traditional knowledge and traditional cultural expressions that require permission for the use. Right. So in summary, the whole idea from creation, from development of AI systems to their deployment, there is IP in the whole of the value chain. Whether we're looking at it in terms of the data for their training, we are looking at the AI systems themselves, or we are looking at the contents that are generated from the AI systems, be it your short article, those who use AI to generate, to write from scratch, be it the pictures you develop from your prompts, be it the videos you develop using AI systems, you know, the whole, or be it the designs, the drawings you develop using AI systems, there is IP. So from production, creation of the AI systems to use and to the content they produce. So that's in brief the connection. But that's not all. What then are the issues from an IP perspective, now that we've seen that IP is everywhere as far as the value chain or the life cycle of AI systems are concerned? Now, if you look at the literature, the issues are looked at from two perspectives: the input side, the AI input side, and the AI output side. Okay, but however the issues you try to resolve, or if you take the issues combinedly, okay, together, the idea really from an IP perspective and from my view is that to be able to develop an AI system or an AI ecosystem that speaks to African reality, we need IP laws and policies that are balanced. When I say balanced, I mean an IP legal framework or policy framework that speaks to incentivization of innovators, of creators, of AI innovators, okay? That speaks to innovators of IP, that speaks to incentivization of IP owners, that is through a bouquet of exclusive rights, limited exclusive rights, right to distribute, the right to produce, the right to manufacture, the right to sell, as the case may be. And then also addresses the public interest in ensuring, in promoting access to information, access to knowledge through inbuilt exceptions and limitations to those exclusive rights. That to me is what I regard as a balanced IP framework. So the exclusive rights do not weigh heavier than the limitations and exceptions. The limitations and exceptions do not weigh heavier than the exclusive rights. Now, I will speak to some of these limitations and exceptions, in this slide. So that's, for me, what we need to be, what we need to have at the back of our mind as we engage with the emerging strategies and regulations in Africa, AI strategies and regulations in Africa from an IP point of view. So, but again, like I said, resolution of these whole issues tilts towards the balance that I spoke about. All right. Now, if we look at the AI, and some of these issues are called crossing, okay? You find them on the input side and the output side. We'll talk about them. If you look at the input side, one of the first questions that needs to be resolved is whether the foundational models are IP eligible. Now, those foundational models, like I said, they've been generated from data. So the data scientists or the computer scientists in the room would agree with me that what happens is that your pictures, my pictures, the articles that I've written that are online are converted, scraped, okay, by algorithms and adapted or reproduced, or both adapted and reproduced into foundational models, which are like that are readable by AI systems. Okay, so they are put into a format that AI systems can read them and learn from them. Okay, fine. So the question now is whether those foundational models that have been, produced and the AI systems created from them are themselves IP eligible. So if we view AI systems as computer software, as computer programs, then we would agree that they are IP eligible. But the question is, what kind of IP protection can we give them? Now, if you look at copyright law provides protection for computer programs, for software. Okay, most copyright laws that you look at. But if you look at patents, not all patent laws provide protection for computer software. In South Africa, for instance, computer programs per se are not eligible inventions to be protected under the Patent Act, except that software is part of a technical process. South Africa has similar laws with the UK. Nigeria, for instance, South Africa also has similar laws with Kenya. Nigeria, for instance, has no express provision excluding software under the Patent Act. And scholars like myself have argued that a non-express exclusion means that software can be patented under the Nigerian law. Okay. Now, South African law finds support apart from the UK. Apart from support in the UK legislation, there is a recent case up to the UK Supreme Court, that focuses on AI system. The question was whether an AI system is a patentable invention, whether it is a patentable invention. And the court held that as far as UK patent law is concerned, up to the Supreme Court recently, that AI systems are computer programs. And to that extent, they are not patentable per se, except they form part of a technical process. All right. So, like I said, software, computer programs, AI foundational models, AI systems are eligible for IP protection, especially under copyright law. Under patent law, it depends on the statutory provision of the country in question. Another issue that arises from the AI input side is whether AI training itself, it's infringing. So recall I said that AI training involves some form of adaptation of existing data, could be existing copyright work, all right, adaptation and or reproduction. Okay. A recent case, which though not related to AI in South Africa, the blind essay case, which the Constitutional Court decided last year, I think, explains the difference between adaptation and reproduction within the context of Braille, converting of copyright works to Braille so that persons who have visual impairment can read. Okay, and the court was of the view that the conversion of the book, for instance, into Braille would include adaptation and reproduction, because you first have to reproduce to be able to adapt. Okay, so if we take that logic to the IP context, the question then would be, is AI training adaptation or reproduction? And you know, for a third party to be able to carry out any of the exclusive rights, including adaptation and reproduction of that are attached to a copyright work, the third party will need permission from the owner of the copyright, except if that use is covered by an exception. Okay, so what that means is, if we agree that AI training involves adaptation, production of existing IP work or copyright work, for instance, then the question is it infringing? Okay, to resolve the infringing question, we can also be asking whether we can regard such as adaptation or reproduction at all. Don't forget that AI training involves scraping through the net, to gather data and converting them to foundational models, like I said before. Now, no court in Africa has addressed the question, but of course, before I go to the courts, related to that question, the question of infringement is whether the training of AI systems is covered by exceptions, IP exceptions, in particular copyright exceptions. And some of the exceptions under copyright law that can find expression within the AI context include the fair dealing exception, which we have under the current South African Copyright Act of 1978. Fair dealing simply says is one of the exceptions that allows the use of a copyright work for individual research, individual study, without, and other actions, other uses mentioned under the Act without the permission of the copyright owner. There is the other variant of the fair dealing exception, which is the fair use exception, that provides a list and an open-ended list. The fair dealing exception provides a closed-ended list, but the fair use variant provides an open-ended list. You have that in the US, you have that in Liberia, and you have that, of course, in the recent Copyright Act in my country, Nigeria. Okay, then of course there is a specific exception that has been developed within the AI context in Europe under the EU IP framework, and in some European countries like Germany, for instance, the text and data mining exception. Text and data mining for computational research, especially where it is in non-commercial research. Okay, and these are some of the exceptions. And then the question is whether we can regard AI training as infringing or as covered by these exceptions. Okay, no court in Africa has determined the questions yet, but we can find guidance in courts in the US, except that the decisions in US and in Europe are still not, they are conflicted. There is no generally accepted position. So if you look at the case law that is emerging in the US, you'll find some courts saying that, it involves fair use, and so it is not infringing. You find some other courts saying, some of the actions that are associated to AI training are not are infringing, are not covered by the exceptions. In the UK, in Germany, there was one of the cases. Now, I'm not mentioning these cases. You can research them because of time. There's one of the cases where the the courts held that the use of pictures for AI training in that case was covered by the text and data mining exception in Germany. Okay, and recently, late 2025, the German court held in another case that the use of music, some musical works belonging to German copyright owners by OpenAI amounts to reproduction, because the court believes that what AI training is, what AI systems do is to memorize. And for you to be able to memorize, in the sense, in the copyright sense, you need to be able, as a machine, the machine needs to be able to reproduce what is there. Okay, and the courts likened memorization to reproduction. The argument of the AI company that the training is not reproduction because it's not stored in a permanent medium failed, and because the court says if you look at, and the AI company also, OpenAI, was trying to argue that they, as the company, are not the ones who, if there's any infringement at all, they are not the ones who infringe. It is actually the users who infringe. But the court was of the view that the prompts by users produce something that is based on what is already in the memory of the AI system. And so, to that extent, that memorization is reproduction, because if the AI system is not able to memorize, to reproduce, it won't be able to memorize. Maybe you should read that the case. Like I said, I'm not going to mention the names. Just check for them. Maybe that should be some assignment for you. But anyway, back to my discussion. In the UK, interestingly, a case involving not music this time, but pictures. Yes, but pictures. The UK court, well, did not really resolve the training with whether the issue of whether AI training is infringing, because the training happened outside the jurisdiction of the UK, and so that issue was not resolved. Okay, but the plaintiff tried to rely on secondary infringement to say, okay, even though the production is not happening in the UK, the system has stored the storage of, the copyright work of the data is reproduction, which is infringing, and the court was of the view that it is not, because according to the court, the storage is not permanent, it is transient. It's like your cache on your search engine. It's not permanent. So the AI system, according to the court, is not hosting it's not hosting the data, so there was no secondary infringement. So you can see that even from the US and the UK, there's still the issue has still not been resolved. The questions are still very much alive. But of course, in the African context, we can find guidance on how to address, these issues. Then on the output side, so that I don't waste time too much on that. On the output side, the major question really is the question of whether AI can be regarded as authors or can be regarded as inventors. Now, you may think that this is not a live issue, but it is actually a live issue, because in the US, for instance, in the US, in Europe, in the US, in Germany, in UK, this question, especially for patent inventorship, has reached up to the highest courts. In the US, the authorship, which is a copyright question, has reached again the highest court. Okay, and of course, all the courts have held that we cannot confer authorship and inventorship on AI systems, because IP is human-centric. The whole foundation about innovation and creativity is human, and AI systems, not being humans, we can't impose or we can't invest them with such power, at least the law as it is at the moment, okay? And the courts have maintained that human-centric nature of IP. But you will find that in South Africa, okay, similar applications that were rejected in those countries that I mentioned was granted by the South African Companies and IP Commission, CIPC. It was an application for patent where the inventor was named as an AI system. DABOS is an acronym for a long word. You can check it out. In 2021, the commission granted the patent without looking at the fact that, the person mentioned here is not a person in law. Okay, now that is the only live an existing patent granted to an AI system in the world. The reason for that is simple. We do not operate in South Africa a substantive search. Also, there's something we call substantive examination, which is looking at the patent system to see if it satisfies the invention, to see if it satisfies three factors. I call them Trinity, the patent Trinity of newness, of non-obviousness, of industrial applicability, right? What we have in South Africa is the repository system, the non-examination system, or the formal examination system, where you file a patent and the guys in the office simply look at the documents. Okay, has the money been paid? Yes. Is there a named inventor? If not, is there an assignment? Just look at the form of the agreement. Does the claim satisfy the form as according to the statute? That is what we have in South Africa. Almost always, this is not even done. The formal examination is not even done. And mind you, it's not just South Africa alone, most African countries, including Nigeria. And so that is the reason why a patent like this that shouldn't have been granted escaped the eye of the administrators, and so it was granted. That is the position now. But that does not mean conferral of inventorship, because it is not it is against the spirit and letters of the law. But again, this is debatable because there are scholars who have argued that, look, we should interpret the patent laws progressively in tune with the current reality to recognize sentient beings. Okay, some have even taken it further to base their argument on I think it's called anthropomorphism. It's a concept. It's a concept in the humanities or so on, social sciences, where imposing human-like stature, human-like features on non-human persons. And so, yeah, that is the conversation now around the question of course, linked to the authorship and inventorship question is the question of ownership. So if we say that that they should be regarded as such, it would then mean that they should then be owners of IP. And then if we agree that that should be the position, how do we resolve the question of liability? Where there is an infringement, how do we resolve the question of liability? Who do we sue? Is it the AI system? Okay, in terms of beyond just liability, what about rewards? Who do we give the rewards? So is it the AI system or the persons behind? But scholars who have argued for recognition of AI systems as authors and inventors have said, well, simply give it to the persons behind. Give it to the maybe the person who used the system to create the work, or the developer of the system. And that is where the weakness of the argument lies. Okay, if we can't then recognize them for reward and liability, why do we then impose a statute on them that carries reward and liability? So these are some of the questions. Of course, the cross-cutting questions again includes whether AI content, AI-generated content, pictures generated by AI systems, pictures generated by books, articles generated by AI systems, inventions generated by AI systems, should they themselves be patentable for patent, or should they find a protection under copyright law? Some countries, like the US, even China, have very extreme approach. If there is no human there's no human innovation or human creativity behind the content, then it is not protected. That's the approach by some countries. Okay, and for China, for instance, the courts have said that where the work in question or the invention in question is AI generated, then the person claiming must show the extent of human involvement. Where the extent of human involvement is low compared to the threshold of originality under the copyright law, then it is not an eligible IP work. That is the approach that countries like the US, China, even in Europe have taken. Again, interestingly, Kenya has that same approach. In a recent case that was decided by the Copyright Tribunal, which involved voluntary registration of a book. Also, the courts held arbiter, because that wasn't the issue before the court, made remarks saying that Kenya copyright law does not accommodate AI-generated works. It only accommodates human-generated works. So if you use your prompts to generate the work, you need to show the extent to which your prompts, contributed to the creation of that work. If it is largely, if there is no causal link, no connection between you, the person, and the AI system, then it means that there is no human creativity, no human innovation behind it, and therefore it is fully AI generated and not protected. Again, another cross-cutting issue is remuneration. Sorry, if we agree that AI training is infringing, then it means that to avoid infringement, AI developers would need to take the permission of owners of the IP in the data they are using before they can use that. And to take permission also includes paying royalties, paying for the license, paying licensing fees. Okay. On the user side, on the output side, if we agree that the AI content is IP protected, it's eligible for protection of that IP law, it also means that the persons who use the AI system to generate the work will need to be remunerated when the work is used. And that is why I put remuneration behind, as a cross-cutting issue. It is real. There is a recent study of the South African Observatory, something of SACO, forgotten the full name, where authors complained about how AI systems are being used to mimic their voices, are being used to mimic their likeness without any form of remuneration for them. Now, whether that is an IP question is another matter entirely. If you look at some of the recent adverts by banks in South Africa, you find that they are actually not real humans, right? They are actually AI generated, persons. Yeah, and behind those activities, authors, actors, performers are complaining about not being remunerated for using their likeness to train AI systems, using their works to train AI systems. It's a big question, and it cuts across both the input and the output side as far as AI IP connection is concerned. I think I've spent too much time on I hope I still have time.
10 to 15.
Okay, enough time to wrap up my discussion. And we're getting now to the policy issues. So like I said earlier on, I'm looking at AI and IP, AI with IP within the emerging AI strategy and regulation. So, to the best of my knowledge, at my last count, there are 16 AI strategies that have been developed on the continent. One is regional, the AU continental strategy, was talked about a lot yesterday, and there are 15 national strategies. Egypt, for instance, is in its second edition. The second edition was released, I think, last year. Then most other ones are currently being released. In the course of my study, I couldn't find that of Senegal and Tunisia in the public space. Then, of course, Rwanda and Ethiopia did not contain any language that, or in my view, I mean, you disagree, do not contain language that speaks to IP. So they are excluded from my consideration. But the other ones have languages that speak to IP, that speak to innovation, that speak to creativity. One major thread that runs through all the strategies, both the continental and the national strategies, is they all want to be, the strategies are developed so that the developers, the policymakers can take advantage of them to be the leading country, the leading continent as far as AI development and deployment is concerned. From an IP perspective, there are two dimensions that I find. There are countries that are pro-protection. I call them protectionists. So what do I mean by pro-protection? Take your minds back to what I said about a balanced IP system. So the language used in the strategies in these countries go towards protecting AI innovation, protecting AI innovators, using IP so the belief of the framers of those strategies is that the best way to develop AI innovation in their country is when AI innovators are protected. So they ignore the other important part of access to data, because to be able to develop a good AI system, for national development, you need access to quality data. Okay, and now how can African AI innovators, AI developers, develop AI systems for the African context if they don't have access to quality data? Now, access to data can be achieved through licensing, for instance, and licensing is not expensive. It's not cheap. It's very expensive. So there may be the problem of funding, to obtain licenses from the owners of the data. In some cases, the owners of the data may choose not to grant the license, even if you have the money to pay. Take your minds back to the HIV, when HIV was really a scourge in this country. There was the developers of ARVs refused to actually license, local ARV developers so that they can produce generics for the poor. So at that time, it was more like a big man's sickness, if you understand what I mean. Only the rich could afford. But it took intervention of the Competition Commission to bring down the price. So, and that's because the competition law had a framework that made it possible to hold accountable the owners of the original ARVs. But the point I'm trying to make by that analogy is that paid access can sometimes be refused by the owners of the data. Okay? And how do you get around this? It's for lawmakers to develop, policymakers to develop an IP framework that has inbuilt access regimes. So exceptions and limitations that match the exclusive rights that IP grants. So the countries that are taking a protectionist approach to IP in the AI context, in their strategy, are ignoring that part, which is necessary for the development of the AI ecosystem in their countries. Now, from my assessment, on the countries on the other side, as you can see from the screen, have language in their strategies that speak to both protection and access. They seem to understand that a balanced approach to IP law, IP policy making is what is important for the development of their national AI ecosystem. Now, the question of whether their existing IP laws are balanced enough to match the strategy is another question entirely. All right. So that's the picture from my assessment of how the strategies look as far as IP is concerned. But if we look at the regulations, remember I said that there is an emerging regulatory framework, landscape for AI in Africa. There's the regional parts. I won't dwell much on that, just to say that the ACFT IP protocol, the digital trade protocol that are not yet enforced, but that have been adopted, contain language that are relevant for AI training. Article 17 of the IP protocol talks about putting measures in place for development of emerging technologies, okay, and even for access to those emerging technologies. Emerging technology obviously includes AI. Broad language includes AI. The digital trade protocol talks about emerging technologies. You need to look at those protocols. The first regulatory instrument, if you call it that, even though it's not strong, it's soft, it's the African Charter on Human and People's Rights Resolution, which Resolution 473, which actually committed member states of the AU to embark on a study on the impact of AI, robotics, and what that study has been done. I think it was put out for comments last year. There's the window statement on AI. It's a regional for SADC. SADC statement on AI, ECOWAS statement on AI, Nairobi East African statement on AI. I found these ones do not really have any relation to IP, but I put them there so that we have an idea of what is happening on the continent, actions towards regulation. So apart from the AFCFTA protocols that I mentioned, the others are obviously soft instruments. They're not hard in any way. Then, of course, at the national front, what we have at the moment are legislative proposals. I found 2 countries. I don't know if there are more. I'll be happy to hear from you if there are more. Kenya recently released the AI bill, nothing about IP. It's essentially creation of an AI commission, blah, 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 and talking about risks, transparency, but not specific to IP, expectedly so. But AI and Kenya is working on revising its copyright law. A colleague of mine, actually Professor Okori, who gave the keynote yesterday, one of the keynotes yesterday, made a kind of jocular statement about Kenya that they produce copyright bills every market day. In other words, they are very quick, very fleeting. Their copyright reform is very fleeting. The latest was in 2022, and now this is 2026. We have a new bill. There was another bill for 2023 that didn't scale through, that didn't go to Parliament. But we had a draft bill that I'm thinking with the momentum will go to their Parliament. And that bill, interestingly, has clause 34 that seeks to introduce, take your minds back to what I said about text and data mining. Kenya is thinking of introducing a text and data mining to their law. So what that will do is that even though Kenya copyright law at the moment is more protectionist because the exceptions and limitations are not strong enough to match the exclusive rights, Kenya is not tilting towards a balance. They are thinking of tilting towards a balanced copyright framework in the AI context, with the proposal for the text and data mining exception. You find it in clause 34 of that bill. Uganda is an interesting one. The Ugandan Copyright and Laboring Rights Amendment Bill 2025 was passed by their parliament last week. Yes, early last week. And it awaits assent by the president to become law. Interesting thing about the bill is that it seeks to introduce a new section 4A, which addresses questions about eligibility of AI-generated works. Okay, it says AI-generated works will be eligible if they are original. Originality still links it back to human creation. Then, of course, it goes on further to say that the protection, the ownership of the work will be vested in the person who generated in the AI system. So what it seeks to do is simply to revise the existing copyright law, not necessarily developing new rules, using the same rules, but infusing AI language into it. Okay, there's no new rules developed, just using the existing rules in the copyright, revising the existing rules in the copyright law. So that is what I found as far as the regulatory landscape is concerned. So now these are the 3 questions that, again, like I said, they are not meant for me to answer, but just to, whet your appetite, like I said, and, go you towards, these directions when you engage with IP and within the context of AI. And to me, the resolution of these questions will really depend on which of the issues, the inputs and output issues, which of them you are engaging with. Okay, for instance, if we're talking about traditional knowledge, traditional cultural expressions, whether AI infringes them, or how to avoid misappropriation, or appropriation of our traditional knowledge through digital sequence information. You know, biotech companies have developed digital sequencing systems that now they can access traditional knowledge that is in the public domain through books, through articles, without, you know, entering into access and benefit sharing with the communities. They can do that from their lab anywhere. And so do we need to develop new rules to address that system, or is existing TK laws, good enough to address? So resolving these questions, actually, for me, depends on the issue that is that you are looking at. And I'll leave the questions for us to reflect on, to ponder about, and then to say on a final note that my keynote is essentially drawn from a paper, and I think Professor Corey mentioned a paper that I authored that we published soon. It's been accepted. It's actually going through internal copy editing. It's soon by the Progesterone Electronic Journal, so it will be open access. And it's part of the special issue that Professor Corey talked about. So that most of what I've said are actually drawn from that paper, and I invite you to read it when it's published. Thank you very much for your time.
Thank you so much, Prof. I feel like I just got a free crash course on AI and IT around Africa and actually around the globe as well. There is a song that I recently learned about. You know, your nieces and nephews will teach you the latest. And it's called Suka, as in the Zulu term, like, get away, Suka. And as they were playing it, they told me this was generated by AI, but it sounds like a typical South African Amapiano song. So the question I have for you, Professor, is based on what you said about the German court's approach. If Amapiano artists were to challenge that particular generation because of the beat and the tone is recognizable from how Amapiano songs normally sound, which direction would South African courts lean towards? Would they follow the German approach, something different, or totally the opposite?
It's an interesting question. First, I'm not the courts, and I don't know if I can actually guess how the courts will address the issues. But I think essentially, courts address issues based on what is presented before them by the parties. Okay, if you look at the German case that I talked about, okay, and I can mention the name. I think it's GEMA, GEMA, and versus OpenAI. Okay, if you look at that case, GEMA is a collecting society. For the IP scholars in the room, a collecting society is an organization that have copyright owners as their members. It could be copyright owners of musical works, copyright owners of, you know, examples in South Africa would be SAMRO. If you heard of SAMRO, SAMRO, yeah. Then for literary works, DARO. So GEMA is an example, but for the musical works. And what GEMA did was to identify the works that are involved in the AI training, the works of their members. So a South African artist would